Dear friends, so today we have our second lecture on civil litigation or dispute resolution, how it's called currently for the SQE purposes, because it covers broader concepts, including dispute resolution. There's more focus on alternative dispute resolution, I would say, compared to the QLTS as a precursor. Today, we will cover allocation and track, related issues, case management powers, striking out as one of those powers, default judgment, relief from sanctions. This is related topic to striking out. Then different interim applications, costs, which is extremely difficult topic in my opinion, and there have been recent changes introduced. This is generally what we are going to cover today. And here with me today is Matt Canning. Hello, Matt.
Hi, everybody. Hi, Olga.
Hello. Thank you for joining us.
Thanks very much.
Just as an icebreaker, and I think it would be interesting for our audience, many of whom are foreign qualified lawyers, many of whom have substantial experience in maybe even in dispute resolution. What do you think your knowledge of French procedure? You are initially French qualified lawyer,
yes,
and you practiced law and dispute resolution in France.
I did, yes.
How do you think your experience and knowledge from France, let's say put it this way, is it helpful for the SQE purposes, or it actually causes some more difficulties in the light that you have to compare with different procedure, you know?
Well, that's a very good question indeed. Oddly enough, it's very much of a disadvantage to have all that knowledge of French law, because it's so different to French law that it's difficult to make comparisons. And sometimes when you try to make comparisons, in fact, you end up struggling more because of that knowledge and the fact that they are different. So you have to kind of unlearn, or rather set aside your knowledge and learn English law, and particularly civil procedure afresh, I think.
I do agree with you personally as well. And I remember when I started at my GDL, at Nottingham Law School, one of the tutors actually told me not to loudly say certain things which are different in the law of Ukraine as against English law, because I can confuse the students, and when we moved to LPC, I completely realized why, because it's even more different and can be even opposite. So yeah, dear friends, so you should a little bit some way adjust, and I think the best approach would be not to compare too much.
Yes.
Right? Try to sort of ignore it, what you have, and sort of memorize it, put it in a different box in your brain, which is possibly difficult to do.
Because I think ultimately the outcomes will be the same quite often. We will arrive to the same conclusion. However, the route towards that is different, and you'll see that in contract. I remember trying to draw comparisons, and those were really unhelpful and would lead to confusion. So yes, please do be careful when revising, not to try and compare too much, because it may well be quite unhelpful to you.
I would even say that these procedural areas of law, like especially litigation, criminal and civil, those are very, very much different, even more. And property practice is something like a completely new thing for me. Great.